Your Honor, I'm Mark Williamson. I represent the movement today, Taylor Shea, the father of the child.
Thank you.
I'm Vicky Shea. I'm representing myself.
All right.
I'm McKenna Isbell, and I represent myself.
All right. Would all those who intend to testify, please raise your right hands and remove yourself off of mute. Do you swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes, ma'am.
Yes, ma'am.
Thank you. You all may lower your hands. So we are here today on a motion to set aside a void judgment. I do have some exhibits that were pre-admitted, and we're going to go ahead and admit those now. So Miss Vicky Shea's exhibits A and B are admitted, and Mr. Taylor Shea's exhibits fathers F1, 2, 3, and 4 are admitted. All right, so we're going to take some testimony. It looks like an order in a suit affecting the parent-child relationship was entered by the court back.
Welcome back to Channel. Before this hearing even begins, you need to understand, this is not just another routine family court case. What you're about to witness is a legal unraveling where a single technical mistake could wipe out an entire court order. We're talking about a situation where a judgment, already signed and relied upon, might be declared completely void, as if it never existed. On one side, you have a father claiming he was never properly served, never appeared, and never even signed the order in question.
On August the 24th of 2021, and there was a motion to set aside the judgment declaring that order void because at the time that the order was signed, the case had already been dismissed. Is that correct?
Well, the challenge today is to the personal jurisdiction over Mr. Shea and what the court just mentioned, which is a technicality, order of pleadings issue. So to be clear, there's the issue of can one amend their pleadings after their case has been dismissed, and would an amended pleading that's not properly before the court support any order? Our position is no. But secondly, the order should be declared void for lack of personal jurisdiction on my client due to lack of service of process, no waiver of citation, no court appearance, general appearance by my client, and the fact that he didn't sign the purported order that was entered back in 2021. So
Okay.
without those, it's our position that without jurisdiction, the court could not have entered that order.
Okay. Thank you, counsel. Let's see. Ms. Shea, did you want to go ahead and, because all you all are doing, you're giving argument of why the court should maintain this order.
It should stay maintained. He lived in my house in August the 2021 because we are taking him back.
Right away, the judge identifies the core issue, and it's not what most people expect. This isn't about parenting decisions, living arrangements, or even what happened between the parties emotionally. This is purely about legal procedure, specifically, whether a prior judgment is legally valid or completely void. And here's the key difference most people miss. A void judgment isn't just flawed, it's treated as if it never existed at all. That's a massive deal. If the court agrees with that argument, everything built on that order collapses instantly. Notice how the attorney immediately narrows the focus to jurisdiction and procedure.
For to work.
Your Honor, for the record, I need to object. Can I share my screen?
Yes, go ahead.
Your Honor, and while I'm doing that, I'd ask the court to take judicial notice of the contents of the file in this case.
Yes, the court takes judicial notice of all contents of the court's file. Counsel, what is your legal objection?
Goes beyond the scope of her pleadings. She filed a response to the petition on September the 2nd, 2025, that wherein she said, I get this to work. She said, her answer says, I'm stating the lack of sufficient knowledge to admit or deny the allegations. As far as I know, we did not have court on August 19, 2021. So for her to now suggest that she does have personal knowledge, that goes beyond her pleadings. So that's our objection.
Sustain. Okay, Ms. Shea, let me say it to you like this. What Attorney Williamson is saying is that at the time that the court signed this order, the court lacked personal jurisdiction, meaning there was some sort of violation to his client's due process rights because he was not served with a copy of your petition or put on notice about coming to court or anything like that. So that's what you would have to defend of why the court should maintain the order. And the order that you have was signed after this court back in 2019 signed an order dismissing the case. So your order that you have from August 24, 2021 was signed subsequent to the court dismissing the case. So you would be trying to explain to the court why the court should maintain that particular order. Does that make sense?
Yes.
Okay. So go ahead.
Okay. The Taylor Shea was living in our home in 21 in August because we were taking him back and forth to work. Julie emailed us the paperwork under my email.
Same objection. I'm sorry, Your Honor. This goes beyond the scope of her pleadings. Her admission that she doesn't have personal knowledge sufficient enough to either admit or deny my client's allegations.
Sustain. So I guess the better way to say it, Ms. Shea, is what was going on at the time of the order is not the reason that we're here. We're here specifically on technical issues resulting in an order being signed when the court lacked jurisdiction.
This is where the attorney starts tightening the pressure, and it's very deliberate. He's laying out multiple independent reasons why the order should be considered void. No service, no waiver, no appearance, and no signature. Each one of these alone could be a serious issue. Combined, that's devastating. Think about it like this. The legal system depends on proper notice. If someone isn't properly brought into a case, the court doesn't even have the authority to make decisions affecting them. That's not optional. That's constitutional due process.
Jurisdiction to sign the order. So let me give you an example. I'm looking at the court's record, okay? This court back August 30th of 2019 signed an order dismissing this suit, okay?
Yes, that's back when in January 4th. Kim Cooks, I didn't know Kim Cooks dismissed it.
Okay.
This was all new to us.
Okay.
As of now.
Let me just walk you through it. She dismissed the case back then, okay?
Yes.
2 years after the case was dismissed, you filed an amended petition, and then you also filed a proposed order on the suit affecting the parent-child relationship. You remember doing that?
Yes.
After you filed that proposed order, the judge back then signed your proposed order after the case had already been dismissed. So at the time that the order that you filed was presented to the court, there was no live case pending at the time. You still follow me?
Yeah, but I didn't know that case got dismissed until here recently when I got these papers. When I went down to get these papers, I did not know it was dismissed. None of us knew it was dismissed. I was getting papers for school.
Okay, understood.
Because none of us knew it was dismissed.
Okay.
And then when I got these papers, he was living in the house. He signed the paper because I had the email. He read the papers.
I'm going to object to any testimony that goes beyond the scope of her pleadings.
Sustain. So again, the court just needs to know, even if you didn't have knowledge, ma'am,
Yes.
legally, there are certain things I'm unable to do just because the law doesn't allow me to do it because I don't have what's called jurisdiction to do so. I have to have jurisdiction to do so. So essentially, what I would need to know from you, not based on what you didn't necessarily know, do you have any case law or anything to present to me today that would allow me to keep this order in place that was signed after the case had already been dismissed?
Like, what do you mean?
Do you have anything where,
Criminal?
no, so
No.
do you have something from a different court, like a court of appeals or something, where another case happened similar to this and the higher told
No.
that they can maintain this particular order after it was signed once a case was dismissed? Do you have anything like that?
No, ma'am. Because, like I said, we didn't know it was.
This exchange right here highlights one of the biggest challenges in court, especially for self-represented individuals. The judge is trying to redirect Ms. Shea away from personal experiences and toward legal arguments. But there's a disconnect. What she's describing, him living in the house, helping with transportation, might feel relevant in a real-world sense. But legally, it doesn't address the issue the court is focused on: jurisdiction. And notice how quickly objections are sustained. That's because the courtroom operates on strict rules about what can and cannot be considered. If something goes beyond the pleadings, it's essentially off limits.
Dismissed until I got these court papers. When I
Okay.
got served.
Okay. Okay. Thank you so much. That answers a lot for me. Attorney Williamson?
For the record, may I call my client to testify briefly?
Yes.
All right. I'd like to call Taylor Shea.
Could you stop sharing your screen, Attorney
I'm
Williamson?
sorry. Yes.
You're okay.
There we go. I'm about to start sharing it again if I have permission. Mr. Shea, tell the court your name, please.
My name is Taylor Shea.
And are you the father of the child that's the subject of this case?
Yes, sir.
All right. May I share my screen, Your Honor?
You may.
All right. Okay. Let me show you what is. Stop doing this. Beg your pardon, Your Honor. All right. Fathers 4 is Fathers 4 is your requested ruling, correct?
Yes.
You're asking the court to vacate the prior order, correct?
Yes.
All right. Fathers 1, that's a copy of the order that the judge signed. And I'll ask you, on the last page, did you sign that order?
No.
Is that your signature?
Yes. No.
I object to that one.
It's a different signature.
Hold on 1 second. I didn't hear any objection because everybody was speaking at the same time. Did someone make an objection?
I did, because that's not his signature.
Okay, so ma'am, what is your legal objection?
I don't have it. Just that the picture that's up there now is not the signatures that are on all the papers I have.
Okay, so I'm going to overrule that. Counsel, you may ask your next question.
Okay. Let me show you Fathers 2. Is that your current signature?
Yes, that is my
And
current
if we
signature.
compare that to Fathers 1, those signatures are completely different, correct?
Yes.
All right. Were you served with process for this amended motion?
No.
Did you make any court appearances for the amended motion?
No.
Did you sign a waiver of citation regarding the
No.
amended motion?
No, sir.
Are you asking the court to vacate the prior order from 2021?
Yes, sir.
In addition, we hired a handwriting expert by the name of Kurt Baggett. Is that correct?
Yes, sir.
Kurt Baggett is qualified and certified by the American Institute of Applied Science and the American Bureau of Document Examiners, correct?
Yes, sir.
And we asked him to compare the purported signature on this agreed order to your signature on Exhibit 2, and we asked for his opinion, right?
Yes, sir.
And his opinion was that the signature on the order was indeed forged, correct?
Yes, sir.
Now we're reaching a turning point, and it's subtle, but extremely important. The judge asks a very direct question. Do you have any legal authority, any case law that supports your position? This is the moment where arguments either stand or collapse. Because in court, it's not enough to say something should be fair. You have to show that the law supports it. And when the answer comes back as no, that tells the judge everything she needs to know. There's no legal foundation being presented to justify keeping the order in place. At this point, the momentum clearly shifts. The attorney has structured a legal argument. The opposing side, unfortunately, is relying on circumstances and lack of knowledge.
This is Exhibit A that I got served with. That is
Your
her
Honor,
signature.
Objection, the document's not in evidence. That's not her Exhibit A or B.
No, it's your exhibit, but that's his signature on the papers that I got served with.
Your Honor? What she's asking my client is not an exhibit.
This is not your signature.
Okay, you all can move on to the next question, Ms. Shea. I sustain the objection.
And I did not. Why?
What was the question, Ms. Shea?
I don't have any right at the moment, Your Honor.
Okay. All right, Ms. Isbell, do you have any question?
No, ma'am.
Okay. Attorney Williamson?
We rest.
All right. Ms. Shea, this is your opportunity to call any witnesses or give any testimony.
I didn't know we were allowed to have those today. I thought it was just us.
This might be one of the most explosive moments in the entire hearing. A handwriting expert enters the picture. And not just casually. This is a certified expert whose opinion is that the signature on the order was forged. If that claim holds weight, it doesn't just weaken the order. It completely undermines its legitimacy. Because a forged signature suggests that the agreement itself may never have existed in the first place. Now combine that with everything we've already heard. No service, no appearance, no waiver. This isn't just a procedural issue anymore. It's starting to look like the order was built on multiple layers of invalidity.
And he didn't sign anything.
Well, none of us were presented with the exhibits of compliances.
Okay. Is there anything further?
No.
Ms. Isbell,
Yes, ma'am.
Attorney Williamson, is there anything further?
No, Your Honor.
Okay. So the court is going to make a finding that at the time that the proposed order was signed, the court did not have jurisdiction to sign it, considering that there was no case open at the time. The case had already been dismissed by the court. So any order that's signed by a court, once a court has lost jurisdiction, is a void judgment. So the court is finding that the judgment is void, and I've signed the order to vacate the judgment.
May we get a copy of that?
Yes, I'm actually sending it out right now to
Very good, Your Honor.
the clerk and my coordinator will forward all of you a copy.
All right. And now that that order's void,
This moment is tough to watch because it shows how unpreparedness can affect the outcome of a case. When the judge offers the opportunity to present witnesses or additional testimony, Ms. Shea admits she didn't know she needed them. And that's a critical misstep, not because witnesses are always required, but because it signals a lack of readiness for how hearings actually work. Court isn't just about telling your side, It's about proving it within a structured legal framework. And without evidence, witnesses, or legal arguments, there's very little the judge can rely on to rule in your favor.
That is a great.
Because Mr. Shea just
Yes, I would like to know that too.
Mr. Shea said he's leaving town next week. He's leaving for a week. He told my spouse that.
Okay, I muted you because I'm speaking and you're speaking over me. As of right now, without a court order, the only people that are allowed to have.
And just like that, the ruling comes down, and it's exactly what the legal trajectory was pointing toward. The judge finds that the court lacked jurisdiction at the time the order was signed, meaning that order is officially declared void. Legally speaking, it's as if it never existed. That's the power of jurisdiction. No matter what the intentions were, no matter what anyone believed at the time, if the court didn't have authority, the order cannot stand. But the impact doesn't stop there. With no valid order in place, everything resets. The court makes it clear there is currently no governing order between the parties, and any future arrangements will require starting from scratch.